Welcome to the first Hoche Hour, which is a place to be inspired by people from legal, like today, from the tech sector and from international affairs. It happens right from Jus Mundi's new office here on Avenue Hoche in Paris. I'm Jean Rémi de Maistre, I'm the CEO and co-founder of Jus Mundi, and tonight with us we have Alain Pellet, with whom I have a special relationship. We'll talk about that further. But first, Alain, thank you very much for being with us. Can you please briefly introduce yourself to the audience?
Yes, first let me say that I'm extremely admirative of your English accent. Mine, after all, is not that better. So, well, first of all, I am a professor. Now I am seen as a practitioner in international law, but I've always felt myself as a professor of international law. I have never taught anything else than public international law, a bit of European law, but I deem it extremely boring. So I was appointed a professor when I was very young. And I first taught in Algeria, and I then was nominated in a small Paris university, which I very much liked, Villetaneuse, but I didn't stay there for a long time. They told me, oh, come on, you should go to a great university. I went to Paris-Nanterre. I was asked several times to go to Assas, or never Assas, or Paris 1, but I felt that Nanterre was much better, where I joined the CEDIN, which is, I think, the most dynamic center in international, at least public international, partly private. And then it happened that in various circumstances, I very much enlarged practice of international law. I became, first of all, I pleaded a lot before the ICJ. I just will plead my 73rd case soon. And I also joined a bit ISDS, which is a field which I absolutely dislike. I'm not an investment guy, although I sit in some arbitrations, and I have practiced a bit more as counsel. And I made a lot of things. I was a member of the International Commission of the UN. I was the legal advisor of the World Tourism Organizations for 25 years. This was tough, much more exciting than ISDS. Pardon?
Because you travel?
You travel, and you don't travel in sad countries. You travel in all world marvels.
What is a sad country?
Pardon?
What is a sad country?
Well, not country, but maybe towns like Birmingham or Turku.
Thanks for this brief introduction. So we have a tradition at Jus Mundi, which is usually to ask people to share a fun fact about themselves. The thing that it's a bit special tonight because I have myself a lot of fun facts about yourself, but I can let you start.
Well, first I could have a lot because I am a scatterbrain. And the number of emails which I send to the opposite side in my practice is enormous. I have maybe a more special one. Personally, it's not nice to say things like that, but I loved COVID because I was in Brittany with my wife, and it was very enjoyable. And you could not plead before arbitral tribunals or the ICJ, and after a while you had to. Everything could not be stopped. So I had to plead in 3 cases, I think, or 3 occasions at least, before the ICJ, and I don't know if you have seen the pleadings, but it's very solemn with big nice robes, in the red robes French counsel wear. And I pleaded before the ICJ with my robe, but under the robe I was virtually naked, and during the pause,
The unnaked style.
during the pause, I just rushed to the swimming pool to join my wife. I didn't. I had no time enough to swim.
So it's funny because one of my fun facts is that before to go pleading, when you go really to the court, I know that you have a ritual, which is that you don't sleep the night before.
Oh, well, if I can, I do. Often you cannot.
And you do your last repetition of your pleading in your bath.
Yes, but not with my assistant.
No.
This is the private one.
I think another nice fun fact is that you love singing and you never miss an opportunity to write and sing a song for special occasions.
Well, yeah, I don't think I am a good singer. I am a better songwriter, but now with the IA, I think copilot sometimes is better. So, no, I start with copilot, then I make it my own way.
Another fact which is less fun but quite important for many people here is that Jus Mundi wouldn't exist without you, and there are several reasons behind that. The first one is that actually I got the idea when, thanks to a job, the first job that you gave to me, that was to make an index of jurisprudence in a book. So you know, before we had computers, the idea, if you wanted to search information, was to use indexes. And so people were spending a lot of time to crack their indexes. And I did that in 2013 as a student. And that gave me the idea, the beginning of the idea of Jus Mundi. I think the other reason why you helped Jus Mundi to happen is because when I was working with you, you allowed me to start working on Jus Mundi and having basically two activities.
No, not for a long time together.
At least 3 years.
I was very generous.
And by the way, so when we were sometimes at the court together, I was building Jus Mundi, and here you can see, so at the ICJ, it's a very, very first version of Jus Mundi that was on my screen, and I took this picture at the time. So this was probably in 2019, I would say, at the ICJ. So yeah, this was instrumental. I think another reason why it was instrumental is because you also you have been an investor in the very early days of your
very small one.
Yeah, but still it was important to give us confidence and some capabilities to pay the first people who joined the team. So that was quite important. The last thing,
no, maybe you will say what I was about to say. That you were my student in your doctoral study, and he started very well. He was quite impressive, and so I said, okay, I will have really good students in IA and things. I think it was IA, and things like that, which at the time were not very fashionable. And unfortunately, he came to me and said, "Prof, could I stop?" I said, "Of course you can. I cannot force you, but it's with much regret." And I left you without shouting or crying.
Yeah. So that was a good memory. And I think the last common point I wanted to talk about is so we did a few trips together. And the last of our trips, I don't know if you remember where it was, but this picture might give you some indication about it.
Oh, it was, no, I thought it was China, but this was Hanoi.
Yes, it was in Hanoi, and the picture was taken the 1st of March of 2020. And we could see like 90% of the people around us at the airport had the mask. And you know, as good French people, we're like, what the fuck, they're totally paranoid, why should we have a mask? And we came back to Paris, and 2 weeks after it was a lockdown, so actually they were kind of right. And so we've been working together for Vietnam for many years. Actually, I lived in Vietnam, and I don't know if you remember, but at that time I was building your website. And there was a guy who actually was in Vietnam with me, who helped me to build your website. He's here. And so it was our first collaboration.
Yes, and I think we met, I think, there. I think so, yeah. Yes, because and you were very good in finding restaurants.
Okay, so let's go into other questions now, and I would like to talk about your activity as a counsel representing governments in front of the International Court of Justice. You've worked for more than 50 governments in more than 70 cases in front of the court. I would like to hear about your first cases. You've represented Nicaragua against the US and Burkina Faso against Mali. Tell us about those type of cases and how maybe the activity of the court has evolved over the last 30 years.
Well, first you are right to put them together. It happens that in 1 week time, I was retained for 2 cases. When people think of me or my CV, they immediately think of Nicaragua versus the United States, which is among at least public international lawyers, which is called the big case. But I think that Burkina Faso, not versus, but Burkina Faso slash Mali is also an extremely important case. I was written very differently, although at the same time. For Nicaragua versus the USA, the agent of Nicaragua was a former commander of the revolution, the Sandinista revolution, and was appointed in The Hague for the case. I came to Paris, and they wanted to have 3 main counsel from the Western permanent members of the UN. Why that? Because they wanted to distantiate themselves from the USSR. They were accused to be communist, and I must say they were not really communist. The main leaders of the Sandinistas revolutions were priests, Catholic priests, left wings, and so he came to visit me in Paris. No, not to visit me. He came to visit first the director of legal affairs, who was the future president of the court, Gilbert Guillaume, and he asked a list of 5 possible counsel. And very strangely, I was on the list. I say strangely because I was quite young at the time. I was 35, I think. And Guillaume, who has become a friend, strangely as well, because he was very conservative, and as I have always affirmed myself, I'm left-wing.
Yes, more communist, that's why they came to you.
That?
More communist? Yeah.
Oh, I was not at all communist. I was very much anti. I've always been, but I was left-wing. This classical left-wing Mendes France, of whom I have been a very young collaborators, but probably it doesn't speak to the audience. And Michel Rocard. So this kind of, but nevertheless, Monsieur Guillaume was rather Giscardien, so anyway, I was on the list, and then my future agent visited the Prime Minister, or the cabinet of the Prime Minister, and he asked for possible counsel, saying, well, we don't want communists, but we want people who are left-wing, nevertheless, sympathetic. And the only name who was on both lists was me. So it was quite, they really thought about it.
And was it because Burkina Faso was also at that time a country that were supported by the USSR?
Burkina Faso was a newly independent French colony, and it happens that the former French Minister for Development and Third World was a good friend of mine, law professors, 10 years elder than me, and he really forced the 2 countries to sign a treaty. And then he was fired by Mitterrand because he was not against the France-Afrique. And so he became a professor, and the president of the court was the Algerian judge Bejaoui, insisted that he wanted to have Cotte as a counsel, and he knew that Cotte would not really make the job. So and I was very close friend to Cotte, and he knew that telling Cotte that I would make the job would probably encourage Student to accept.
And if I can ask a side question here, because you've been working with the African leader, who is like probably one of the most impressive of the last 70 years, with Thomas Sankara, and with everything which is, I think, happening over the last years in the Sahel. What's your views about that, about this leader, about what happened after? What is your memory of him?
Well, first of all, I wouldn't say that I have worked with him. I was retained by his country. I suppose we will have occasion to speak of the relations between Council and states. But it happened that he received me the first time I visited Burkina Faso. He was a wonderful guy. He was handsome. He was witty. He was quick. He understood everything, and except that when he arrived, they let me wait with my agent, who was the ambassador in Paris, the Burkina ambassador in Paris. They let me wait, and after a while, he arrived with a gun, with a gun in his pocket, put it on the table. I thought, well, I am in front of an African dictator with a gun, I must behave correctly. But he was shy, and I don't look probably shy, but I am shy. So both of us were a bit intimidated by the other. And after a time, I laughed, and I said, well, Mr. President, we must speak. And he said, oh yes, Alain, we must. And then I think he enjoyed speaking with me, and I was said that he was he liked to had visitors in the middle of the night, which is good for me because I work usually in the middle of the night. And at 11 p.m. he sent me his officers to fetch me and to say, well, the president wanted to see you. I was not that, but he was absolutely lovely. We discussed of everything but law. He was extremely impressive. He was assassinated by his best friend, who is still the dictator there. No more, but who has been the dictator for quite a long time. But I wouldn't say that he was a dictator. He killed, I think, virtually nobody.
You mean Sankara?
Yeah.
Sankara.
No, Sankara was a real dictator with blood on his hands. Sankara, no, well, except in one occasion.
But that, I think, leads me to the question about the relationship with your clients, because it's quite special to represent states, governments. Do you say, by the way, that you represent states or governments?
States.
States, yes. I
represent states, but sometimes the national administration and the government think that they are representing themselves more than their states. That's an interesting debate between them and me, or people like me.
So you consider that your responsibility is going toward the state itself, and so how do you approach the relationship with the client?
Well, first of all, it is my responsibilities are for my state, and not for the courts or the judges. I hate the common law way of saying, oh no, we must help the court. Of course we don't help the court. We help the client in trying to have the court to find its way. There are two parties, both parties do the same, but I think this Anglo-Saxon idea, oh, we want to help you, we will help you, come on, it's rubbish. So I don't want to help the court. You must never lie to the court, at least for the facts. And sometimes when my clients, even if they are states, want to change the facts, not very often. I've seen that maybe once or twice. In that case, I would resign. But dissimulate cases, facts that happen. This happens all the time, and I fight against this. It may happen that I yield to that because But it's silly because first, usually the other side gets the documents or and I think it's much better to anticipate that. No, you give the facts, but I remember some occasions where I have accepted to say, okay, let's keep it once or twice, and maybe I did accept that five or six times, and I think once or twice it was quite damaging. So you must be, and this supposes that you have relations with your clients based, I would think, on two main quality of dialogue: frankness and faithfulness. You must be frank with the client. I would say I have not many private clients. I have had some, notably before arbitral tribunal. So it's the same. I think you must be frank with the client. You must first of all say to the client, whether it is a sovereign state or not, I don't agree, or you are wrong. I am very much. I have the bad reputation of being very straightforward, and some of my colleagues are much more polite, and they prefer to be nice with the client. I am not. I think it has no help. And usually when I take the case, I say, I first never take a case before having an idea of the file. I insist, I want a file. It can be just, you can take out anything you want, but I want a file, because I would not accept it if I would have to say things which I don't want to say. And so this is the first contact with the client. You buy it or you don't buy it. And I think during all the process, you must tell your client, your state, on that, no, honestly, it's but also, you are not the boss. Quite often, usually now, nearly all times, I am the lead counsel, so I am the lead of the legal team. But I am not the boss of the case. The boss is the agent, the representative of the government, and I think that first quality of counsel is to be able to yield to the politicians, just telling them, but what you want me to say is just stupid. And well, then you sometimes I have pleaded things which I thought was totally ridiculous, because I am an old chap, but I have done that for a very long time. After all, I think I can take the silly parts of the case. I will not die with this.
I think it's important to realize that when you represent a government, and so you plead for a government, everything that you will be saying in front of the court is somehow engaging the government. So usually, or maybe all the time, you have to write down your pleading entirely, so it can be checked by the government, because it will have legal consequences. So it's less maybe spontaneous.
Yeah, although it's not always, not that often, because the government are not stupid. After all, we are hired to win the legal case, and if they have retained you, they are rather confident in you. So it's really a dialogue, and more often the opposition between the political side and the legal side of the team means that you change the form of your pleadings. I am rather brutal, but the court knows me, so they don't. The court doesn't mind my brutality in pleading, relative brutality. But so when my clients say, "Oh, must we really say that?" I say, "Well, you must be clear also with the court, but quite often I have to change the words, but not that often the strategy. The strategy is discussed with the client.
And so there is a deep discussion with the client during the pleadings, of course, to align on the strategy.
Not during the pleading.
Sorry, during the preparation of the pleadings. And I think there is also the after decision. And I remember a story that you told me about a case which is called the Preadear case. Maybe you've heard about it recently. It's a temple dispute between Thailand and Cambodia. And recently this issue started to arise again. And apparently Trump is one of the wars that Trump stopped. But this is a very...
one among the
nine.
Now I think it's at least 9.
But this is a very old issue between those two governments, and it has been solved during more than 30 years, like thanks to this...
From 90, well, the dispute was before, but the dispute before the court started, I think, in 1958, something like that. The judgment was given in 1962, and then we went back before the court more recently. But I'm always back in recent dates, but 1990 something.
And I remember you telling me a story because it was very difficult for both governments to accept any laws because for the population it was a very important case.
It was still because they are merely at home.
And it was followed on TV, etc. And so the acceptability of the decision, I think you remember you telling me that it's part of the responsibility of the lawyer, of the counsel, to help justice by making the decisions acceptable.
Yes, and usually I think people, good counsel know a bit in advance what will happen. So you prepare the client to lose that and that point, or to lose completely. And I think it is extremely important to be frank, to say, okay, we will do the job, there is no shame in losing, but we will lose. And sometimes they go to the ICJ to lose. I am sure that Gaddafi in Chad, Libya, accepted to go before the court because it was a lost case. They knew it. He had very good counsel, advisors, and he wanted to stop it. And I had told the Chadian dictator, who was a very nice chap, a good friend. He became a good friend, but he was a real dictator. After my time, he became a real dictator, and I told him immediately, of course we will win. And I'm sure that the advisors for Libya did the same. We will lose. But sometimes it's good to lose before the court, better than to lose lose before military.
I mean, the goal of public international law is to settle, one of the goals of the court is to settle disputes. And it's a way to do it, sometimes for government, to push the responsibility to a third party, and so they don't give in toward their population or their...
Yes, and I think also there are limits. Personally, I have quite often, including recently, told my client, don't go before the court. It's too hot. It's of no use to go before the court when there is a war. Law is not made to stop the weapons to speak. You must, and I've seen no case where there was open armed conflict which was fit to go to the court. So sometimes I'm not followed. And this case, the previous case, is like that. They will never accept. Whether Thailand or Cambodia, they cannot accept. I must say, I am counsel for Thailand. I must say that I really think the 1962 judgment is absurd. First, because legally speaking it is debatable, many judgments are debatable, but when you go on the spot, the temple is really situated. It cannot be reached from Thailand. It can only be reached from Cambodia. Sorry, it can only be reached from Thailand. So the judgment itself created an impossible. So they feel that.
Maybe I want to go on what you say. So law is not made to stop wars, and it's not the moment to start a case. But so if I take you on the topic of what has been happening over the last years in Palestine, because not that you are the lead counsel of Palestine in front of the court, I know it's a case that started before everything that has been happening the last 2 years, when the US decided to move its embassy to Jerusalem, which was forbidden by international law. But there is a case that has been started by South Africa.
It is still pending.
Yeah, and so do you think it was a mistake to start this case from South Africa?
Well, first it was the embassy in Jerusalem case was not at all concerning. It was, of course, a burning issue intellectually, but it was not at all about armed conflicts. It was really just, it was a breach of international law, of important rules, especially immunities, things like that. But this is not the kind of things I had in mind. But what you could ask, and then why go to the court on the Gaza case, or Gaza aspects of the big context of Israel and Palestine issues? I think this I could not. So for the embassy, I rather encouraged it, saying, well, yes, it will embarrass the US, show, because at the time it was still quite important to show that they did not respect international law. Now, what is the use of that? The madman in Washington doesn't care about international law. In any case, why at the time it was still, Trump won, it was still important, at least for the public opinion in the US, to show that what they were doing was simply impossible. For Gaza, it's something different. I think it is a desperation case. When you see that nothing can work, at least you can. And it worked in a way. Advisory opinion. Everybody tells me, well, come on, advisory opinion is not binding. What does it matter on that? It doesn't matter whether it is binding or not. The court says what the law is, and it is rather respected. It is respected. So at least you have this satisfaction that there are the bad ones and the good ones. I think this is such a sensitive issue that when you have decided that this was the responsibilities entirely on the Palestinians, no use to say that. But the same is true the other way. But I think I am very happy to have been and to still be the lead counsel for Palestine. Of course, you would say, yes, but South Africa is not Palestine. Well, they did the job that my Palestinians hesitated to take to the court because they are afraid of a lot of things.
But wouldn't you say that maybe it's one of the values of international law in those situations? Because when there is a war situation, usually it's part of the communication plan to invert the system of values and to make it unclear with actually violating some rules, with the good, with the bad. Everyone sees himself as a good, and international law brings some objectivity in a situation, and so having the court giving an opinion about the situation helps to draw the line and maybe to give some...
You are a man of 3 centuries ago. 3 centuries have passed since Trump has been re-elected. Now, I think this reasoning is all right for normal people, but we are not in situations where normal people are president of the most influential countries. So really, in French, we have a very nice expression, which is pisser dans un violon, and really thinking that the three main dictators in the world are sensitive. No, it's wrong. Thinking that Mr. Trump, Mr. Netanyahu, and Mr. Putin are sensitive to the any call for international doesn't mean anything. A bit more maybe for Netanyahu, because there's probably a small part of the Israeli public opinion which is still interested in low cases. But I had said the three main dictators. Netanyahu has become a dictator, but he is one of the three main ones. She is more sensitive to that, but only when China is at stake. To say that what Putin is doing, he doesn't really care. He just sees his interest or Chinese interest.
So I've heard in your words several times public opinions, and actually I could also observe myself how much in preparation of the pleadings governments are also concerned by their public opinions, even governments that can be dictators, real dictators, dictatorship. Don't you think that if we want to dream about a future where international law will play a bigger role, this is where the answer is? We had a discussion with the team 1 month ago, and I was taking the example actually of the constitution of countries.
The
constitution of a country. If we take the US today, what will prevent potentially someone in the US to do something is the constitution, but the constitution itself won't do anything. Yeah. It's because the people of the countries are, at the end of the day, maybe ready to die to protect their constitution. Should we arrive one day to a situation where, okay, people around the world, humans, beings of this planet, are ready to defend international law, international legal values, because they know this is more important, and so the public opinion is a real way to help to build a more peaceful world?
Well, partly I agree, partly I disagree. First of all, when you have a war, it's too late. So if you want to do something, it has to be done now, not. And I am among those who are extremely pessimistic. I think there will be a war in Europe, much more important than the Ukraine war. I am among those who think there was an interesting article in Le Monde 2 days ago of an historian who said war will be in Europe, not elsewhere. So I am extremely pessimistic, and I think that you are right to say that the fight is not so much at the international level. It doesn't mean much to have an international action also. Maybe I would like to finish on an initiative I took recently. You can try, you must try, but I think what is important is what happens inside the countries. When you see the way Israel has turned from a really democratic country to a country which is very little democratic anymore. When you see the way the USA has turned, which was a kind of modern democracy, after all, they had their Declaration of Rights much before the French, after the Brits, but after the English, but before the French. It is one of the motherhood of democracy. And when you see the way they are turning, now for me, the USA is a dictatorship, with some checks and balance, but as you, I think, said or meant, law can do nothing by itself, or say the judiciary cannot exist by itself. It exists, it can impose itself, because the executive branch is ready to support it. In the inside the US, Trump is as negligent or opposed to law as it is internationally. So it is for the public opinions in the countries to try to avoid going to a dictatorship. For me, we are really in 1936, 37, 38. And when you see that Italy is turning fascist, Germany is turning, the Weimar government was wonderful on the paper, and it was a real democracy. At turn Nazi, no, we have these we have Orban is somebody who is terribly dangerous. The new government, the new administration in the Czech Republic are extremely dangerous, and with the domino. So I am extremely bad fight inside France for the French among you. Fight inside. I have been told that there were many Indians here. Fight against Modi. He's, from my point of view, somebody who is progressively taking this enormous democracy to something which will very soon look like a fascist country.
So I think you're right that the purpose of international law is to not arrive in those situations. So it has to prevent before. So let's do like an expérience de pensée, and let's say that after some difficult times, we have the possibility to redraft the international legal system, to redraft the UN with something different. How would you do it? What would be the main characteristic of the system that would be different from what we have today to prevent this from happening again?
Well, first of all, I am not a communist, contrary to what you seem to have implied when we started, but I'm still a Marxian. I still see Marx had wonderful intuitions. I still think that law is the son or the daughter of the social situation, economic and social situations. And I think that you can imagine the future law only if you imagine the future international economic and social system. So you cannot do anything just saying, oh, it would be good. My view, I am sure that law will not disappear in that, but for the moment it's going more and more in a terrible dimension, which is that instead of being a law between states, it is becoming a law between empires. And empires have a very big difference with law, with states, not with law, but with states. States, by definition, they are sovereign, but progressively I wonder if I don't hate the word, because it doesn't mean that you are sovereign, you can do everything you want. It means that you can do everything which is not contrary to the equal rights of the others. And states do accept that. As a matter of definition, a state accepts the other states, whether big or small, are equal. An empire is not. An empire is an entity which wants to dominate as much as it can. There has never been a world empire, and neither Xi Jinping nor Trump, even if Trump is succeeded by this horrible Vance, they will never have the empire of the world. This is clear. But if you have several empires, they will of course have a residual law, because the state of war can only be temporary. Even if you take the Guerre de Cent Ans in Europe, the 100 Years War, or if you could at the end of the Middle Age, or the war of la Guerre de 30 Ans at the end of Louis XIV century. at the beginning of Louis XIV. 30 years is very big, long for a war. It was not all the time. So at some point it will stop. And during the period when they stop, of course they will have to have relationship, they will have to exchange goods, to receive a voice from the other. So these aspects of law will stay. But I am very pessimistic on the rest. Can we imagine to reconstruct with the situation as it stands, without changes, social and take something which does not, but maybe it's my left-wing aspect, take something which does not really interest people as climate change is seen as something terrible. I think it is rather terrible. But I am even more disturbed by the rise of inequality. I think the rising inequalities inside the states, democratic states, as well as in the world, are something which is probably more threatening than anything on the long term. Because with money you can buy so many things. You can buy minds, you can buy honesty, you can buy everything. So
You can buy states.
I am definitely one.
You can buy states.
You can buy states. So yes, although even provinces for the moment, or small non-state entity like Greenland resist, and I think they must resist. But I think bigger entities like the EU should resist a bit more. And when I say a bit, I'm far from the truth.
Before maybe to move into more positive views, I want to talk briefly about investment arbitration. And investment arbitration is a lot of what we've been doing at Jus Mundi during the first years. And I know that you have terrible views about investment arbitration. Can you tell us about why?
Well, you certainly know my view, you know my basic views because in your new review, Jus Mundi review, you published I think in the first, you published my article, which is called the 7 Capital C's of ISDS. Well, first of all, you must keep in mind that it was invented by the Western world against what is called now the Global South, the newly independent countries. And at the time it was acceptable, because at the time it was true that the judiciary in these countries was not independent, globally not independent. It was true that the judges were not yet well formed, and it is understandable that after all there was an interest both sides. So I am not against the investment law as such. It can be useful, but now suddenly the West have realized that after all they could be the victim of investment, and now they think, well, it's a bit this investment law is a bit complicated, but for us, why? For us, we have wonderful judges who will always protect. So it's still the double standards. It is one of the reasons why I am not very favorable to that. I must say, and I think that at least in a country like France, I would much prefer that the French judges decide than 3 people who are chosen, one does not really know how and why.
Thanks to Jus Mundi.
Pardon?
They are chosen thanks to Jus Mundi.
That's what?
Chosen thanks to Jus Mundi.
Yes, and I never use Jus Mundi for that. I use it for other reasons, but not for that. No, or you competitors. I think it's awful. Although I think it is very important that at least they are not too much conflicted. But honestly, what is their legitimacy? None, except the interest of the investors. Sometimes a bit of the states, but the states have, their interest is to be sovereign and to be able to decide who can do what in the country.
some people would answer you that most of the investment arbitration cases are actually won by the states.
Not most, the majority.
Yeah.
That's, I mean, try to be a bit nuanced on that. It's not, and it is more true than it was at the very beginning. It is true. But this is the reason why ISDS, sometimes de l'urticaire, I don't know how you say that in English, and I don't like the community of which you are an important, more and more important part. Why don't I like this community? Because it is all about money. It is, I am absolutely, I have acted in not that many, but probably 10 or 12 ISDS cases. Not all are public, because also secrecy is something I disapprove, and many or several are. But I have seen the way the law firms work, both from the point of view of the arbitrators and from the point of view of the colleagues of counsel. All is about money. Law firms have only one thing in mind: to earn as much money as they can. The result is terrible. The concrete result is terrible. The cost of a case before arbitral tribunals is raising. This you don't like too much, you people from this community, to speak about. But it has raised us incredibly. Just and it is law firms. I am more against a law firm than against the investment law. But the law firms, they just try to, when you discuss with colleagues from law firms, now they have invaded the small community and less community before the ICJ. In my first cases, when you had a case, say, equivalent, it was much less than the case, but say equivalent of $3 million, it was just unthinkable. We could do a case before the ICJ, which, if I may say so, is sometimes more important than to know if the contract has not been respected. It was, I would say, the average would be the equivalent of today's 1 or 2 million. I have always told my the states who come visit me, don't take law firms. I can do that with my assistant for 1 million, 1.5 million at most. Now, the cases before the ICJ are just equivalent from the cases before, big cases, I would say, before the before arbitral tribunals. Probably you have cases which are 20 million, and I think it's just stupid. It's a shame.
Maybe AI can help here, because with a small team and just maybe one assistant, indeed, even if he works a lot, you can achieve much more and handle those big quantities.
Okay, although I find your fees quite expensive, quite big, we have to discuss this again. I agree with that. I think that ISDS saves a lot of time. This, I agree. But it doesn't, I see in 2 cases recently, I don't know why they don't choose me more as a president, because I have voted probably more often for the investor than for the state. But there is something which I have always refused, is to accept that the losing party must pay the fees when the fees are excessive, when they are normal, decent. I yield to my colleagues. But when not, I really threatened them. I told them, hey, okay, I have voted on the substance because I think the investor is right, but you will never convince me to accept that 20 million fees, or it can be the states. The states are stupid. They more and more ask law firms, while they have very good internal professors, law professors who can do the nearly for free. Just a last nearly anecdote. Now that after the publication of my article, I have a bit less now, but still, I am asked to make speeches or participate in debates in ISDS meetings, and I say these kind of things, and I always finish by saying, "You are corrupted by money." And they applaud and they are enthusiastic, nearly standing ovation. I think they are really masochists.
Well, maybe I can share also, though, I won't comment on that, but I can share also a perspective. At Jus Mundi, we have many governments that are clients of Jus Mundi. Actually, the first government client came thanks to an introduction by you. It was a Japanese Ministry of Foreign Affairs, but now we have something like 50.
And I'm very much in favor of for the government, just like for anybody, to use instruments like yours, not possibly for the conflicts of interest or for grading the advocates, but for the research. Yes, I think it is very good, very helpful. Well, yes.
No, and we see them more and more building internal teams to lower the cost. So I think that's a good evolution.
Yeah, but you are pleading for your parish, for Jus Mundi. But I am pleading against these big law firms who prefer to charge uselessly, honestly uselessly. It doesn't matter to add 4,000 pages of annexes. It's stupid. No arbitrators, don't tell me it's not true, because it is true. I have never seen arbitrators reading 4,000 annexes. This is simply impossible.
One comment. Before maybe we open the floor to some questions from the audience, and then I will at the end come to the last question. So we've talked about the limits and the negative perspective of international law. If I turn now to the 70 years of existence of the court, what did it achieve? What do you think that the court helped to preserve some peaceful situation in certain moment, and does it?
Well, it's not 70 years. It started in 1920.
Yeah,
there is really a continuity. Well, what was the question?
So, do you think it has achieved something, and there is some recognition which is deserved maybe for the court?
Well, I think the court is accepted as saying the law. You lose, you are unhappy, but you say, well, after all, it's a word court. We have accepted to go before it because the consent is really the basic principle. Of course, it can be interpreted more or less largely, but it is. So the court is respected as a law saying, not as a law making, although sometimes I think they make the law, but it's usually rather reasonable law. So it is really accepted as a decent law sayer. And sometimes it's very interesting. And international is what it is. There are a lot of holes in international law. And you don't have a law maker in international. You have some, but very little. So I think the ICJ, I wrote an article on that I made a lecture which has been published by the Hague Academy on the evolution of international law. And I think that the best law making in international law is probably the ICJ.
And do you think it had a meaningful contribution to peace over those years?
Well, probably it avoided some. Recently I took an initiative which was directed against the clown Trump, and it was because at the time, I think even some months ago, there was a risk that he got the Nobel Peace. The Nobel Peace has been given to not worse people than him, it's impossible, but to very bad people, or at a bad time, not too early for Obama, for example. No, not because Obama is a bad guy, not at all, but he should not have got the Nobel Prize at the time. So I was really anxious that this guy could not get the Nobel Prize, and I wondered what the hell could help the Norwegian committee to find a good Nobel Prize. And I thought, the ICJ. The ICJ has never got it, whether between the wars or after. So I thought, after all, they might be attracted by that, because, and especially after the last year Nobel Prize, which they gave to a fascist Venezuelan who gave her prize to Mr. Trump. So I think it was horrible. And I suppose if these people are decent people, and they are probably they are conservative Norwegian, I thought, well, after all, it's a good idea. I must say that all people to whom I have spoken were very much in favor. So we have made, but I didn't want to make a I say it publicly. There is nothing secret in that. But and the campaign is finished since 31st of January. You cannot nominate any candidate to the court anymore. So now I can speak rather freely of it. But I got 506 signatures of very high level. Not enough politicians, which I suppose is important for the Nobel Committee. But I am a legal man, I am not a political. But nevertheless, we had the president of the Slovenia, the president of the Republic. We had former President Hollande, not as a former president, because former peoples cannot sign. Only the president, chief of state in duty can sign. So I had Holland, several former president of the ICJ. I did not ask judges of the ICJ, except three friends. Two of them have signed. So it as well. So this is my way of thinking. You can try to influence, but you can do nothing more with law. And they have been influential. I hope they will be more influential, but that's, I suppose it more or less answers your question.
Are there some questions from the room? You can take a few questions.
You can ask whatever you want. I am not sure. in my public.
And you can speak in the dark part.
Oh, wow.
And speak loud, because I have some problem with.
Can you hear me?
No,
Can you hear me?
come closer.
Oh, wow.
Don't put it like that, and we don't see your nice face, but we see the blue thing.
Okay. Well, first of all, thank you so much for the talk and for being here. And I had 2 questions. The first one, since you were pretty clear about disliking investment arbitration, something with which I agree, but I was wondering, we know that in investment arbitration, arbitrators have a tendency to be inspired by public international law, by private international law, even human rights law, because of what some call a conceptual mess in investment arbitration.
You call what?
A conceptual mess.
Yeah.
So I was wondering if you think, or if you've seen, that investment arbitration impacted public international law in like the other way around, with like investment arbitration jurisprudence.
Let me to answer this one before the next one.
Thank you.
I don't think that investment arbitration has influenced much general public international, although in a case I remember I had fight very hard. It was a Diallo case, which was a human rights case mostly. I fought hard to convince the judges to take on board the evolution of investment law, and they imperative, no, this is rubbish, we don't care about that. So that way I think it doesn't really work. The other way, there has been progress. At the beginning, your conceptualness was, yes, I was totally invaded by private international lawyers and they knew absolutely nothing in public international. Progressively, the state have understood that it was good to nominate public international lawyers. I think it would be as good for private investors, but they do that less. But you have had people like James Crawford, Brigitte Stern, Gilbert Guillaume, who have been extremely influential. You can think whatever you think of Brigitte Stern, who is a good friend of mine, by the way. I think I don't approve her behavior. I think it's impossible that the states are always right. But she is seen as a hard worker. She takes seriously her job, and she has helped, as the other I've quoted, or other Von Lowe, for example. I think all these people have helped changing the view of the investment lawyers on investment law, and the eruption of public international have been quite spectacular. And I must say that I don't say that I am a good investment lawyer, but I would say I have really no problem to understand how it works, and I don't feel that I am that bad. I am not good, but I understand well. I hate damages. This for me, I go to Washington next week, and this for me is horrible, because experts lie, and when you have experts lie, but they lie both sides. So since both sides experts lie, how can somebody who is not an expert in financial matters can find it his or her way? So this is terrible.
You can ask Hussein who is right. You can ask Hussein who is right between the two experts.
Well, I could try, but first you have to be able to formulate the good questions.
Yeah, the second question is a bit quicker. So since you've been representing Palestine for a few years now, and seeing, like the sanctions, for example, against the French judge in the ICC, I was wondering if you've ever faced anti-Semitism accusations or something like this. That's what I was wondering if you've ever been accused of anti-Semitism or things like this, because this is the main discourse right now, and what people use to discredit anyone that represents the Palestinian cause or Palestine. Or that was just a question.
It's a question. Why did I take the...
No, the question is, have you ever been accused of anti-Semitism?
Oh yeah. Well, yes, of course. Yes, of course. But we are, whatever some people now think, we are in a democratic state. I have been asked several times to give lectures in universities on the Palestine cases. Whatever you may think after this meeting, I am rather moderate. I have had never any problem of speaking of terrorist attack. I would have probably a bit more problems in speaking of terrorist Hamas, describing Hamas as terrorist as such. But I have spoken extremely freely, with not hiding my reservations on some aspects. I have had some questions, but usually quite moderate also from the audience. So no, I have not. The first time I did it, it was in Angers University, and I really tried hard to find somebody the other side. All of them who were involved refused. But an Israeli professor who was very good, Yuval Shani, accepted. He was not involved in the cases. And after the discussion, I told him, well, after all, we think exactly the same thing. He was an anti-Netanyahu. I would have liked to find a Netanyahu, but the one we tried refused. And he was just a Zionist defender. But so no, I have never felt that there was a big austerity, maybe because my audience is well chosen. I don't know if among you want to attack me on that. I'm ready to answer.
I think it's good to remember that there are not only two sides. That's where we tend to see in those cases, but I think there are three sides. There are also the side of those who just want peace in the middle, and they need also to be more vocal.
If they only want peace, they are Trumpists.
You choose.
Oh,
Thank you very much, Professor. So you mentioned that big law firm only care about money. So what would be, according to you, the good and the ethical way of practicing
Self-restraint.
arbitration law, especially as young practitioner?
Pardon?
So what would be the most ethical way of practicing arbitration law?
I think not trying to have meetings, endless meeting when you can do it in 10 minutes. Not trying to say, we must do a lot of more searches when the lawyers say, no, we have enough, don't, not checking every comma. If there are some errors in the text, doesn't matter. Not just having in mind that you must make money, just trying to have in mind that you must be efficient, that you must take into consideration the client, that poor client cannot be pressurized, but they have a right to be defended. Things like that. It's really, it was not a joke when I answered quickly, self-restraint. I think it is that. I don't think I have more.
I have some memories of you making sure your assistant check commands.
Yes, because I didn't want to do that myself. But I have not fined you because you forgot. No, sometimes I was shocked at, come on, this GR, he has not made the job. But well, okay, it doesn't really matter. What matters is the whole process.
Hi, I'm going to ask a very silly question.
Okay, go on. If you have silly question, I reserve my right to have silly answers.
Have you ever been followed by spies while representing governments? And a follow-up question to that would be, have you ever held information that made you feel like I need to hire bodyguards?
To what?
To hire bodyguards?
No, and I don't feel the need. You can ask my wife if I have been terrorized by in a case saying, hey, come on, lock the door. No, it's not my style.
But have you ever been followed by spies?
I suppose my computer, my clients would say, we must encrypt and I tell them, come on. My main enemies usually are China, the US, Israel. Of course, I have access to my computer. So why the hell would I take precautions which probably have no meaning? And also, and this is not modesty or things, honesty, what I do is just something important for the client, but it will not change the fate of the world. So if the opposite side knows fortnight what we will tell the court, honestly, it doesn't matter.
Thank you.
But there are a lot of people that side.
Hello, and thank you so much for your presence and everything you shared with us. I have two questions. First question about the ICG. Do you think it's easier for the ICG to resolve cases between countries from the southwards than to resolve conflicts between a country from the north and a country from the south?
Well, may I enlarge your question, because I think we had planned to say something about that. Well, first of all, For the ICJ, it doesn't really matter, I think. For them, it's neutral. They are state, they are sovereign state, whether from the south, whether from the west, if the west still exists. So for the court, it is, thank you, for the court, it's rather neutral. But there has been a real evolution. In the past, during the PCIJ time, the clients were, of course, there were Western countries. Then there was a terrible judgment, Namibia and South Africa cases, where the court really made a political judgment anti-African states, which was useless, outrageous, really. So they decided not to come. And we were speaking of Burkina Faso and we deviated. But Burkina Faso was the first case where countries from the south came back. This is why I said it is both, not only Nicaragua and the USA, but also Burkina Mali were very important cases, because in both cases, Nicaragua was a small country from the south, won against Reagan's USA, and Burkina Mali was extremely well received by both countries, so much that the Malians wanted to decorate me, who was Counsel for Burkina, because we were friends. It was, and the court the chamber made a very balanced judgment, taking into consideration really all it. But don't understand me. I don't say that the court cut, how do you say, couper la poire en deux in English. No, mitigates. The court does not mitigate when sometimes you can have 100%, you can win 100% or lose 100%. But then this judgment was, and then the South has come back, the West has not. Now there is only one West of the three permanent members. There is only the UK, with so many reservations accepting the jurisdiction of the court. So, second question, because I think that the boss is coming.
Yeah, we don't have a lot of time for questions.
Yeah,
so quick question, quick answer.
It's about international law. Do you agree, how far, or do you not agree about saying international public law was established by strong countries to protect their own interests, and we just, if we want to have something that's, find peace, we just have to abolish all of it and find another system. The system now is actually corrupt and just weak.
Well, maybe it's not exactly an answer, but I would say law, and not only international law, is always in the hands of the powerful. So that's true for. He wants. No, but there are a lot of questions there. So I tried to.
No, good, very good. I was thinking and I forgot to get this piece.
Hi. Okay.
Loud.
Okay. I have two questions. I'm going to be quick. The first one is about ISDS. You talk about different criticism, and my question is: do you think that all the different discussions that are being held right now about the reform of ISDS, with the creation of the multilateral court, can help to improve the ISDS, or what is your opinion on the different reforms that are being taking place right now?
Well, my answer, so I try to make them short, is yes, I think it's better than nothing. Some are in good direction, but there are small technical changes are not, they do not change the system. And again, I think it's more, the progress is more a question of behavior than a question of changing the legal aspects. I would prefer not to have ISDS, but we have it. And I think, yes, you can have the ILA can make some progress, but nothing more. Next.
The next one is about international public law. Among all the cases you have pleaded, which one do you think has the more impact on international public law?
So this, I have 3 cases, which were my cases. Of course, the USA, the Nicaragua, the big case, which was, well, first it was my first case, equal with Burkina, but also it was something extraordinary that this small country putting its fate in the hands of the court. And it was l'enjeu, the scope, the aim was really terribly important. My second was the first genocide case between Serbia, between Bosnia and Herzegovina and Serbia. I was not in the Croatia case, Croatia versus Serbia, because I had said bad things on Croatia during my pleadings for Bosnia, so I thought it was bad for my clients, so I said no to the Croats. But it was terrible for me because it was the first time I was confronted with a genocide, and the court was a bit disappointed. The judgment is a bit disappointing. Of course, we won in that they recognized that there had been genocide acts, but in such a small scale that it was disappointing. And for me, it has been more regret than a victory. And the last one, not last one, last ones, I see my job for Palestine as a whole. So for me, the Palestinian cases are a whole. I am not counsel for South Africa because I wanted to stay for Palestine and to try to put Palestine in. I would have a lot of things to say about that. But nevertheless, I am following South Africa. We discuss with Palestine, we discuss with South Africa, and we try to inflect a bit their strategy with which we do not agree 100%. And Palestine has intervened, and we are still discussing whether we intervene as a party, which I think would be logical for Palestine. If the state of Palestine exists, it must be, when it can do something, it should do it. But they're afraid. It's not easy to be the state of Palestine by the time being. But for me, it's a whole. I am really fighting for something in which I trust the funds of the Palestinians.
So you were mentioning the fact that you work on genocide cases, and for example, there are cases like Bosnia and Herzegovina, like there is sexual violence and stuff. Like sometimes do you need to take like some distance from your workload? Like for sometimes when I imagine you must be like seeing so much like atrocities. Is it sometimes hard on as a person, and then do you need some time to like?
Well, first of all, I don't only work on genocide or terrible cases, so some are quite relaxed. Even if they are usually not relaxed for the client. These are sovereign cases, and I was, certainly you would be horrified, but I was counsel for Japan in the Wales case, and I must say, Wales are lovely, of course, but I think we lose, Japan lose very much. But I must say, I think we were right, legally speaking, but we cannot fight against Wales. It was clear that we would lose, and I warned the Japanese that never we would, and we had 3 votes, the 3 best judges. All the others voted against us. But I don't always work, fortunately, on genocide or crimes against humanity or atrocities. One of my really best friends in professional but also friendship was Antonio Cassese. He was the first judge in the ICTY, the International Criminal Tribunal for former Yugoslavia, and he resigned at the end because he said, I cannot endure anymore all these atrocities. Then he was the first judge in the ICC, International Criminal Court, and he resigned again because after a while, he was an excellent judge, but he was somebody who he thought, I have to go there because this is terribly important, but then he could not do it. For me, it's different. I am not, first of all, it's rare, it's not my professional life day to day. These cases are terrible. I have lost a lot of white after one of these cases, second one, but, well, I have other things.
I remember because we worked together on the Yukos case for a month, and when I was also looking, because some aspect of this case are also
Yukos,
but what happened after, I think, the nationalization, and I was a bit touched by all of that. And I remember that you told me, because it's a bit different also the fact that, as a lawyer also you represent your client, but you cannot always believe that your client is in the right position.
But this doesn't really matter.
Because
right or wrong, it doesn't matter.
Because it's your job, and that's important, and I value that very much. But I remember you told me, in this case, it's a gangster against gangster, so you don't care about that.
Yeah, but that said, I am not cynical. I think that I choose my clients not so much because they are good guys or bad guys, but because they have an acceptable case or an unacceptable case. This for me is different. I have been a counsel for Iran until rather recently because I am against unilateral sanctions. And I think pushing people to die, not individuals, to die is terrible. And I said yes. The first time I said yes was more for friendly reasons because they really needed, I am not indispensable, but somebody like me, because at the 3 weeks before the pleadings, one of their main counsel had resigned. And I think it was wrong from him, it was unethical, and I was probably one of the rare which probably would have accepted, who would plead for Iran at the last minute. You could not just arrive having never had a case, and Crawford was lead counsel for Iran, and he really begged me, please do it, and I think I was right. And then the sanctions against Iran, but usually, this is another debate, but usually unilateral sanctions for me are negative. Everybody's saying multilateralism, and then everybody takes unilateral sanctions. There's something illogical in that.
Okay, last question.
Thank you. Easy and light question at the end. You mentioned that you believe it will be a war in Europe. So my question is, what kind of war it will be?
A real war.
A real one, maybe nuclear, maybe.
Pardon?
Like the proxy, the hybrid, the real one, nuclear, maybe.
Which country are you from?
Ukraine.
Yeah. I think the same as Ukraine.
The same.
Maybe not in Paris, but probably in Poland, probably in the Baltic states. This will be real war, and if we don't ourselves, the French, make the war with them, then it will be, they will just have to, they will just have to comme on dit, cueillir les fruits mûrs, to take the fruit when it is ripe, the fruit will be ripe. So, no, I am terribly pessimistic. Not so much for me because it can take some years, but for your generation.
And who will be the main players?
Pardon?
Who will be the main players?
Well, I think Trump is not concerned, so it will really be the good boys like us and the bad boy who is not that powerful, but who is armed and doesn't hesitate to send his people to die. And while we would too. Just look at the horrific reaction of the French public opinion when Major General said, you will have to accept that your children die. The French were horrified. But I'm afraid that you will have to die, because or to accept that the word can be divided in three or four main empires, with some countries surviving here and there. No, I am very pessimistic.
The younger generation, let's hope that the younger generation will be more promising than what we can think today. But let's move to the final question, that are the questions that we'll be asking everyone at Hoche Hour, and that are also designed maybe to bring a perspective for the future. The first one is, if you have one book that you would recommend to us, one that has shaped your thinking, a book or another resource?
Well, I will recommend two. First, unfortunately, it is only in French, but for me it is the most wonderful book which has been written on the use of law, of international law. It is called La politique juridique extérieure, external legal policy or policies, which was written by a former director of Foreign Affairs in the Ministry of Foreign Affairs, Guy de la Charrière, who unfortunately it has never been translated. It has just been re-edited in French, but at a scandalous price. Doesn't matter for people like you who are rich, but for students it's impossible to buy that, and even for public library. It has been re-edited by Brûlante, and it is wonderful because it's both cynical in a way, saying, whoa, well, of course the state side doesn't buy their interest, forget with international law when they are opposed, and it's wonderfully done with a lot of spirit. In French we say spirituel. It's witty. This is bad in French, and this is very unfortunate. It should really be translated because it's a book forever. It's not. And the other is totally different. It's not a book. It is the reports of one of my intellectual masters, Roberto Ago. Ago is the Italian professor of international law who invented the new law of responsibility. And reading his first articles and his reports, which I think are in the late 1960s, I've realized that after all, law is not contractual. Law is a system for governing societies and to defend societies as well. And before him, the mainstream was law is made of treaties. And there were exceptions, and Grotius with natural law was different. But the mainstream was that, with some exception, like the French Georges Sell, who is said to be my master, but I am more Marxist or Marxian than he was. So these are my two. And all the reports of Roberto Ago before the ILC are, of course, in English, translated. He wrote in French, but were all translated into English. They are very easy to be found on the website of the International Law Commission. And it changed really my view of international law. I thought, when I came to that, but it was in 1968, I think, that I started international law. When it came, I read that, I understood that no, law is not a problem of contract. No, law is a much wider field, which is a problem of norms, and all norms are not equal. All this I learned it from Roberto.
Okay, so who would you recommend us to invite to next Hoche Hour session?
Well, then I received this question in advance, And my understanding that was that you want to receive lawyers, and my two recommendations in my head were Brigitte Stern, precisely but with the hope that you can have some fight, because we fight, her and me, although I am really grateful to her because she changed a lot. But I think it is interesting, provided and I tell her, come on, it's impossible to be always pro-state when you are but she's still nominated, and her co-arbitrator are very positive on her. She doesn't change many things.
But Brigitte Stern is the arbitrator with the highest number of awards on Jus Mundi, for your information.
Yes, only women are at the top. But not enough women as a whole, but too many at the top.
And the other person?
And the other is the former president of the ICJ, Yusuf Abdelhak Yusuf, is a Somalian, and he has an incredible career. He just came from a village in Somalia. He then was the head of the, he then had several jobs. He then became the head of legal affairs in the UNESCO, and he then was elected as a judge in the ICJ. And he's a wonderful man, very open to discussion, very much having the sense that he's an African. He must assist the African states to try to use international law, to take it seriously. He's wonderful, he's very modest, very nice. So these were my two ideas, but they are lawyers. I think that you can also invite other people.
Yeah, we won't invite only lawyers, but we can have other lawyers as well. And so those are great recommendations. I have a last question. You said with the recommendation of the book that one of the goals of law is to protect society. It's actually the reason why Jus Mundi's logo is a shield, because we have also this vision that law is here to protect society. And Jus Mundi, the way we describe Jus Mundi's mission today is to power global justice. My question to you is, so it's two questions. What does justice mean to you, and what advice you will give to younger generation to help move the world in that direction of what justice is to you?
Well, I don't know in which sense you use justice, because justice is the institutional side of, so it's judges, courts, tribunals, etc. In this way, I see it as a very useful institution, which which is probably before which you can solve dispute in a civilized way. So this is the basic view. Justice can be something different when you think of divine justice, which I don't trust in at all, but if you take justice in its very wider sense, what it is to try to avoid our basic instinct and to think that we are not animals, although I have a strong view that I am an animal, but an animal who thinks, and that to forget the negative way of being a human being and trying to be a positive mind, a positive human being, but
and how to
be in a decent way, to not to lie, not to just things like that. I think that the moral here, I think it's no more a problem of law, it's really a problem of moral ethics, and I think there are ethical ways to be a lawyer.
Alain Pellet, thank you very much for being with us.
Thank you.